single order to admit the applicants, Colonel Retired Dr. Besigye, and had obeyed in the mandatory bail. So that they are released from custody where they have been on remand since the 20th of November 2024. And for brevity, it was since November, 20th November 2024. And the provisions of the law under which the application is brought are stated in the notice of motion. But the thrust is in Article 23, sub-Article 6, paragraph C of the Constitution of the Republic of Uganda. My Lord, that application is supported by the affidavits of the applicants, and in response, when we join that with affidavits in response of the state, the applicants swore and we have filed affidavits in rejoinder. My Lord, our colleagues, the state were served with the affidavits, the notice of motion, the affidavit in support, and the affidavits. My Lord, the uncontested facts are that the applicants were arrested on the 16th of November 2024 in Nairobi. They are contested. They are not contested. Reading the affidavits, those facts, the applicants were arrested on the 16th of November 2024 in Nairobi, Kenya. 16th November 2024, including offenses relating to security, contrary to section 128, subsection 1, paragraph F of the UPDF Act, Cap 330, laws of Uganda. I know they were charged with various offenses, some under the Firearms Act, but the one which is pertinent is offenses relating to security, contrary to section 128, subsection 1, paragraph F of the UPDF Act, Cap 330. My Lord, we state that offense because the penalty for the said offense, if found guilty, is that the accused person suffers pain.
Are you saying counsel the charge in this application is under the UPDF Act?
My Lord, there was a transfer. There was a transfer of proceedings to the magistrate's court. So the
what is the
current one?
Yes.
Following the transfer now,
yes.
is prison and misprision of prison. My Lord, we are making a nexus because there is an unbroken trend of the period of remand, which is the gist of Article 23(6). So, my Lord, and they were remanded on the same day to Busia government on the 20th of November 2024. My Lord, there was no second remand.
So the remand is started when?
The remand started on the 20th of November 2020. And they have been in remand in custody since that day. My Lord, following the decision in Supreme Court Constitutional Appeal number 2 of 2021, the Attorney General versus the Honorable Michael Luka, it was delivered on the 31st of January 2025. On the 31st of January 2025, the charges were transferred from the General Court Martial, the civilian courts. On the 21st of February 2025, the applicants were charged under Nakawa criminal case number 8 of 2025 for the offenses of treason,
This number
8 of 2025. Uganda versus Colonel retired Dr. Kiza Besigye and Hajo Bay Mutale. And Captain Samola is not here. But then those charges were read to them on the 21st of February 2025. And they were further remanded. I know that forms the gist of our application, because as the court asked, there was no interception of any liberty, not even for a minute, for the accused persons. So the applicants have never gained their liberty since the 20th of November 2024. And they have been on remand in Luzira government prison since that day. My Lord, the remand since 20th of November 2024 exceeds 180 days. To be precise, my Lord, the 180th day accrued on the 19th of May 2025. 19th of May 2025. And my Lord, this application was filed on the 29th of May 2025, which is the 190th day. 10 days after the constitutional deadline, 29th May 2025. My Lord, correction, my colleague says it was filed on ICMIS on the 28th of May, but stamped with the court stamp, physical stamp, on the 29th. I beg my pardon. And because this court has made a pronouncement in that line, the consistency between the charges in the general court martial and the charges at Nakawa is that the penalty on conviction is death. Meaning that the offenses of that nature cannot be tried by a subordinate court. And as the court has found, my lord, an application for bail in that case is brought before the High Court under Article 139(2) of the Constitution. 139(2) of the Constitution. And my lord, that is per the decision of your learned brother, the Honorable Mr. Justice Isaac Mwata, in the case of Besigye Enoch versus Uganda. Criminal business application number 133 of 2025. Criminal business application number 133 of 2025. And my lord, that decision is intended to cure the lacuna that was caused by the declarations in Attorney General versus the Honorable Michael Kabaziguruka, and hinges on the decision of this court in the case of Aaron Kiza versus Uganda. The decision we have cited which was determined by the High Court took into consideration the remand of Mr. Enoch Besigye pursuant to the orders of the General Court Martial. So that the period of remand of Mr. Besigye via the orders of the General Court Martial was taken into consideration in determining the constitutional deadline of 180 days. And in the Aaron Kiza case, your learned brother, the Honorable Mr. Justice Michael Erubu, he invoked the powers of court under Article 139(1) and Section 17 of the Judicial Act to cure the lacuna which would otherwise have been an injustice to the applicant in that case. My lord, the argument we are making is that factually, the applicants were remanded in November, 20th November 2024. That the charges now before court are treason charges vied Nakawa Criminal Case 8 of 2025 does not negate or wish away the fact that they were in custody by the time they were charged in Nakawa. So those days when they were in custody, my lord, between the 20th of November 2024 and the 21st of February 2025 cannot be wished away or swept under the carpet. And that is the reason, my lord, why the Honorable Mr. Justice Mwata and the Honorable Mr. Michael Elubu Yonane brothers invoked the power of court to cure that lacuna. And in reasoning, they were fortified in the view that there should be no uncertainty in applying the law, and that the law should be predictable to inspire confidence. Because when there is any uncertainty, the injustice caused may result in oppression. May not be content that using that authority, the time within which to count 180 days, as the decision provides, starts at the beginning, which is the 20th of November 2020. And we maintain, therefore, that the transfer to the magistrate's court was not a fresh start, but a phase in the same process. The law is very clear. Article 23(6)(c) of the Constitution that where a person is arrested in a criminal offense, triable only by the High Court, and who has been remanded in custody, or who is on remand in custody, for 180 days before they are committed to the High Court, my lord, just for 6C, that where a person is arrested in respect for a criminal offense, in a case of an offense triable only by the High Court, if that person has been remanded in custody for 180 days before the case is committed to the High Court, that person shall be released on bail on such conditions as the court considers reasonable. My lord, in this case, we have stated that the 180 days accrued on the 19th of May and unlike what is stated in the affidavit in response, the applicants were committed to the High Court for trial on the 29th of May 2025 and not the 26th of May 2025. But even though it was the 26th, which it is not, it was still the 188th day, 8 days after the expiry of the constitutional deadline. My lord, that provision is re-echoed. In the Constitution, open brackets, bail guidelines for courts of judicature. Constitution, open brackets, bail guidelines for the courts of judicature, open brackets, practice, close brackets, directions 2022, which is legal notice number 8 of 2020. And my lord, it is guideline number 10, paragraph brackets 1. My lord, the words in that guideline are exactly the same as what is contained in Article 23(6)(c). Has been on remand. Rather, I beg your pardon, that the applicant is charged with an offense triable only by the High Court. In this case, treason, and which mutated from the offense contrary to security, also triable capital offense. Once the applicant has been arrested and is charged by an offense triable only by the High Court, and has been on remand for 180 days without committal, that person shall be released bail on such conditions as the court considers. My lord, the operative word is shall, and in particular reference to this provision of the Constitution. The Constitutional Court, in constitutional reference number 20 of 2025, Uganda, in brackets PPP, versus Colonel, retired, Dr. Besigye, has found that the court must release the applicant, and unlike Article 23(6)(a), there is no discretion exercised regarding bail, the grant of bail. The discretion is exercised in respect to the conditions for the grant of bail. My lord, we have cited the constitutional reference 20 of 2005, the one I've alluded to. My lord, that position was reaffirmed by the Constitutional Court in Constitutional Petition number 20 of 2006. The Foundation for Human Rights Initiatives versus the Attorney General, with the findings of the court in the aforementioned constitutional reference. And my lord, at page 22, and fortifying the other decision, the court held thus: Lord, it held that, if I may read, as regards Article 26, I beg your pardon, 23(6)(3), sorry, 23(6)(c), where an accused person has been in custody for 180 days on an offense triable by the High Court only, and has not been committed to the High Court for trial, that person shall be released on bail on reasonable conditions. And the court found, like in Article 23(6)(b), like in Article 23(6)(b), the court has no discretion to refuse to grant bail to such person. The court has a discretion to determine the conditions of bail. The Constitutional Court in that decision found that the matter regarding mandatory bail was settled, and there was no reason whatsoever to interfere with that finding, which has been reached. And my lord, for good measure, for the applicants, the decisions were citing were uploaded on ICNIS and all are available. My lord, in applying those provisions in the constitutional reference and the constitutional petition, we have referred to it. The High Court of Uganda in Chinyambira Mumbere Boniface versus Uganda, my lord, Chinyambira Mumbere Boniface versus Uganda, criminal misdemeanor application number 87 of 2012. Your learned brother, as he was then, the Honorable Mr. Justice Lamek Mukasa, found that when the threshold of the 180 days has been met, the one in Article 23(6)(c), the 180 days has been met, the court has no discretion but rather has an obligation to release on bail. Its discretion only lies in determining the conditions of the release. And my lord, in that matter, the state raised the point that at the time that application was heard for mandatory bail, there had been a committal. The application had been overtaken by events because there was a committal subsequent to the expiry of the 180 days. And my lord, that is the position in the affidavit in reply, where the state, the deponent contends that this application is overtaken by events because of the committal on the 29th of May 2025. My Lord, your learned brother Justice Lamek Mukasa then was found that the subsequent committal had no bearing on the application. Because by the time of the committal, the 180 days had accrued. So the constitutional deadline of 180 days had already materialized. So that the right of the applicant to mandatory bail had already arisen. The relevant part of the ruling, my Lord, reads that in the Eastern case, the applicant was charged on the 27th of June 2011. The Honorable Mr. Justice Cavallo, in the case of Joseph Luce versus Uganda, 1997, Volume 3, Kampala Law Reports at page 58. Again, in that case, my Lord, the state opposed the right to mandatory bail by arguing that the applicant had subsequently been committed for trial and therefore he could not be released on bail. The committal having happened after the constitutional deadline. That an accused person whose constitutional right to bail has accrued, an accused person whose constitutional right to bail has accrued, an accused person whose constitutional right to bail has accrued under the provisions of Article 23(6)(c) of the Constitution. It did not in any way remove the right of the applicants to apply for bail. My Lord, that position has been carried in the more recent decision my Lord, it is criminal witness application number 21 of 2025. Besigye Stephen versus Uganda. Besigye Stephen versus Uganda. Sorry, my Lord. In that case, the Honorable Lady Justice Grace Flavia Lamuno my Lord, the court in that case took a proactive approach in light of the rights of the applicant in that case, Mr. Besigye. And found that where, in line with Article 23(6)(c), where in line with Article 23(6)(c) and Guideline 10(1) of the bail guidelines, a person charged with an offense tried only by the High Court who was being on remand for 180 days or more without committal must be released on bail. And in that case, the court has no discretion to deny bail. My Lord, the court took the view, which we align with, that to continue to hold such person in detention beyond this period without them having been committed is inconsistent and contrary to the constitutional guarantee of mandatory bail. My Lord, the court taking a view that mandatory bail is guaranteed to an accused person by the Constitution. The applicant need not apply. Once the court, on its own calculation, finds that there has been a breach of the constitutional deadline, it must release that person. In Komakech Robert versus Uganda, miscellaneous application number 29 of 2024, your learned brother, the Honorable Mr. Justice Isaac Muata, found that the article and the guideline make it mandatory to release such a person on bail. Learned brother said that an accused person automatically qualifies for mandatory bail once they have been on remand for more than 180 days before they are committed. So it envisages a committal after the 180 days, but if it is made after the 180 days, then that person qualifies automatically for mandatory bail. And in such case, what is left for the court? What is left for the court is to determine the conditions the applicant has to meet for their release, before their release. My Lord, your learned brother also gave guidance in his finding that even in determining the conditions those conditions, the court only has to deal with the questions only has to deal with one question, whether the applicant will abscond. That is the question. My Lord, in their affidavit in response, the state raised objections which shall point to quickly, because most of the points have been covered. But in pointing them out and responding in our submissions in regards to those objections, we are mindful of the test set by the Constitutional Court in the Besigye reference and the foundation for human rights petition, and all those decisions by your brother judges and sister judges, where they have stated that mere assertions are only speculating and cannot remove the right which is guaranteed by the Constitution, which has matured as has been the case in the matter before this court. Or the level of participation of the applicants. My Lord, it is such statement which your learned brother warned the court, mere assertions which are speculating and which fall far, far short of removing the entitlement of the necessary bail. And my Lord, they base the calculation the state contends that there are 168. 68. 160. They calculate from 21st February 2025 up to today, perhaps. And we have submitted in the case of Mwesiti, where your land brother, in curing the lacuna caused by the Honorable Kabazi Buruka petition, the appeal to that petition for charges which stem from the General Court Martial. And also referring to the Aaron Giza application, that the court must intervene where there is such a lacuna. But it's not the making of the applicants, that the state pursued a course of action that was deemed unconstitutional by the Supreme Court. The applicants are merely victims of that unconstitutional order.
My Lord, I will refer you to the decision of the Besigye Stephen, miscellaneous application number 021 of 2025, a very recent one. My Lord, July, to be exact, by Justice Flavia Kumuno, 30th July 2025. And my Lord, on page 4 of that decision, your sister had this to say: bail under Article 23(6)(c) of the Constitution was introduced as a safeguard to prevent the state from keeping accused persons in prison indefinitely without trial, particularly where the committal process has been delayed. The court is therefore required to strike a balance between the applicant's right to liberty and presumption of innocence and the public interest in ensuring that those charged with criminal offences approach justice. And she concluded by saying, in doing so, the court should impose conditions that are fair and reasonable, allowing the accused to enjoy the benefit of mandatory bail while also making it possible to ensure that the accused continues to attend court as required and to be test. So the point here, my lord, is that the right to bail under Article 23 was meant to guarantee enjoyment of the right to liberty and also safeguard the processes of this honorable court.
Profile. Popularity is not a ground for denial of liberty. Even if you are not mandatory bail, I think it is irregular for the state to be envious of the accused. The point of liberty has been succinctly clarified, but one of the fundamental points of mandatory bail is actually stop trial without detention. Detention without trial. And these are not my own words, these are the words of the Constitution. And the Constitution adumbrates them in the Article 43. The twin purpose is prevention of political persecution. Again, Article 43 succinctly and expressly outlines that. It is a factual reality that the accused are being politically persecuted. Although it goes without saying, the accused have taken the trouble to outline it in paragraph 13, paragraph 13 of their affidavit. Paragraph 13 of their affidavit talks very clearly about the political persecution that the accused have had to endure.
My Lord, the provision is in respect of actual bail. Our application, my Lord, is not for a discretionary bail. And indeed, my Lord, the bail we are seeking, today the applicants are not here for a right to apply for bail. But rather to receive a bail, my Lord. Deliberate and intentional. It was premised on, among others, the oppressive and imprisonment without trial, which was characterized, I beg your pardon, which characterized our political history, my Lord. My Lord, denial of the right to a mandatory bail by the applicants now before you will be so detrimental to the values and the wishes the framers of the 1995 Constitution intended to achieve, my Lord. My Lord, I invite you, my Lord, to stand tall over the unsubstantiated allegations advanced by the state to persuade you not to grant the application, my Lord. My Lord, I beg to rest.
I have only one or two things to say. Firstly, to reject the proposition in the paragraph 17 of the respondent's affidavit that the applicants have only spent 167 days. We just want to emphasize that there is only one state, and that is the state of Uganda. And
Since they have been, since they have been in remand for only
167 days. They deliberately refused to account for the period between 20th of November 2024 and 20th February 2025. They admit that period in their affidavit, but they refuse to account for it. And I've said there's only one state, and it is the state of Uganda that was holding them between that period, which is 90 days. So if you add 90 days to the admitted 167 days, that's a whooping 257. But if we count up to today, it's 263, as indicated by my colleague, Elias. You have the final word. Count the dates from actually the date of arrest. The date of arrest or abduction in Kenya by Ugandan military to live with the Kenyan military. That matter is subject of a case in the courts of Kenya. The other point, you have been told that the applicant, the first applicant, has been in many cases. What the prosecution is saying, this is in paragraph 18. They even cite an existing case, which is case number 624 of 2023. Kindly note, my lord, they are not talking of convictions. They are talking of prosecutions they have mounted against him without securing a single conviction. Prosecutions designed to keep the first applicant in custody, just like in this case. You can only quote previous antecedents when a court has pronounced itself and there is a conviction. For the case that is pending before the Nakawa Court, 624 of 2023 criminal case, the prosecution cannot have their cake and eat it. Why have they not concluded the prosecution since 2023? You come to cite a case where again you are guilty of laches. The associates who are accused of singing are not named, nor are tapes of what he finds, the music that he finds not good, not so melodious to his ears. So it's a mere allegation. And what if others have done? Are these two applicants going to be punished because others have done? We are asking the court to ignore.
Richard Lilivumbuka, Chief State Attorney.
Yes, Chief State Attorney.
Yes, my lord. My lord, as respondents, we are working as a group, as a team. And there's some information, my lord, which was brought here while we were in court. For example, in respect to security, for which as a team, not as a single prosecutor, we need to deliberate upon before we make our presentation. The sureties and some
The sureties will reply later, but proceed.
my lord, the principles of fair hearing that we seek a standover of 30 minutes to proceed, to be able to proceed. And it is our submission that we ask for 30 minutes to prepare and be able to reply.
Let us proceed. Where you have reservation, point it out. This presentation, where you have reservations. Let us proceed.
What's your plan?
There are some things you need clarification. We shall reach there.
My lord, we have no option but to proceed. My lord, I'll make the presentation for the respondent. This application is solely hinged on whether or not the applicants had clocked mandatory and whether court can go ahead and admit them to bail premise on the above, my lord. My lord, whether or not the applicants had clocked mandatory, it is a submission that by the time of committal, on the 29th of May 2025, the applicants had not clocked mandatory. In fact, by the time of filing this application, my lord, which is the 29th of May 2025, the applicants had already spent 98 days on remand. 98 days on remand. Yes, my lord. My lord, we refer you to paragraph 15 of the affidavit of Detective IT who conducted Besigye Festo in respect to the first applicant, and paragraph 12 of Detective Inspector of Police who conducted Besigye Festo in respect to the second applicant. My Lord, the applicants were remanded in custody on the 21st of February 2025. And that was the time when the Office of the Director of Public Prosecutions had taken over or had instituted fresh investigations and therefore brought fresh charges against the applicants. My Lord, the applicants were charged with, on the 21st of February 2025, they were charged with treason and misprision of treason. My Lord, it is not true, therefore, that the DPP was in charge of this matter, of the applicant's matter, while they appeared before the General Court Martial on the 20th of November 2024. Much as we acknowledge the office of the DPP is provided for under Article 120 of the Constitution. And under Clause 3B of the same article, the office of the DPP has no jurisdiction over matters that emanate from the General Court Martial. These are two different institutions. Whereas the DPP is under the Constitution, the General Court Martial is a child of the Uganda People's Defense Act. In fact, it is an absurdity to hear the applicants argue that the office of the DPP had jurisdiction over the charges that the applicants were facing before the General Court Martial. But the respondent shall not repeat what the applicants stated about the charges against them before the General Court Martial. but we shall simply emphasize that those charges which they were facing before the General Court Martial are completely different. My Lord, would refer to the case of your brother, Honorable Justice Dr. Douglas Kalkona Singiza, while handling Civil Division Miscellaneous Cause number 31 of 2025. Number 31 of 2025. As the applicants, we are seeking a right of habeas corpus. My Lord, I just want to go through this briefly. Just right from the argument. My Lord, a copy of the same is here, and we have actually highlighted. I'm going to give it. That is retired Colonel Dr. Chiza Besigye and Obed Rutare versus Attorney General and Commissioner General of Prisons. Those were the parties. My Lord, my senior colleague, Honorable Medard Savona, as he is, submitted as below. That the transfer, that is true, the transfer of the General Court Martial files to the DPP and the civil courts is legally impossible. Since that court had no power to try the applicants in the first place. Just for emphasis, my Lord, what you're about here, my Lord, is my submission. Is that the rationale of that is that whereas the UPDF and the General Court Martial fall under the military justice system, the civil courts fall under the civil justice system. Bundling the two would be a legal error. Doing so would infringe the constitutional provisions in brackets on the prosecutorial powers of the DPP. My Lord, that view was also echoed by my senior colleague, Lord Mayor Elias Lukwago, counsel for the applicants. Now, in that application,
My Lord, allow me import directly and quote verbatimly what the judge had to say. He said that, as understood by this court, the applicant's position is that to the extent, and my Lord, this is on page 10, that to the extent that the Supreme Court decision nullified the power of the General Court Martial, GCM, to try them, they remain in illegal detention. On account of the uncertain administrative processes that seek to implement the Supreme Court's decision. Besides, all previous cases before the GCM, General Court Martial, had equally collapsed. And could never be resurrected by the DPP. Because, my Lord, this is very interesting. Because doing so would be constitutionally improper. He further stated that under Section 56 of the Evidence Act, Cap 8, Section 56 of the Evidence Act, Cap 8, this court is enjoined to take judicial notice of the proceedings of 21st February 2025 in the Chief Magistrate's Court of Nakawa at Nakawa, in criminal case number 285 of 2025, in which the applicants were formally charged in the courts of law and remanded. While the court would have wished to answer the issues raised